In the Idaho 4 Kohberger case, there have been a lot of orders and other things coming out of the court recently. We are going to take a look at the top 5 orders in the Kohberger case and also a bonus. The trial is getting closer and closer in the Idaho 4 Kohberger case, and there have been a lot of orders coming out of the court lately and a lot of other documents. So rather than looking at all of them in this episode, yes, the top 5 orders. Hi, I'm attorney Andrew Myers. This is About the Law, and joining us this week is California attorney Yolie Medina.
Hello, thank you for having me again.
How have you been? We haven't seen you for a while.
I've been fine, busy.
Good. I saw that you did an episode on jurors and whether or not they should be able to go and see the scene of a purported crime, and the fact that that can't happen in the Kohberger case, basically because they knocked it down. That was a great episode. Could you just summarize for us really quickly what your message was? And I will put a link down in the description area.
Yeah, essentially, I was reading an article or going over an article that talked about 5 trials where the jurors visited the scene of the crime and how it helped them to finally decide that, beyond a reasonable doubt, that the defendant was guilty. And one of them was the Murdahl trial, and the other one was the trial of it was Joe McGinnis' book. The defendant unalived his family and tried to make it look like the Manson murders. And for 9 years they kept that house. And when the jury went to visit it, it still had the red stuff that said pig on the walls. So it was very, very powerful. So in this case, Kohberger, the house is so unusual. I mean, the house is 3 stories. It has unusual areas, and it would be beneficial, especially if they have experts who have done time runs and showing how one person could do this, which doesn't show Brian Kohberger did it, but just the house itself, how unusual the house is, and but they won't be able to do that. So instead, I guess they're going to get a dollhouse or something.
And we've talked about this in previous episodes, and I've said, and I'm not going to belabor the point, but I just don't believe that these radars or lidars or recreations. I don't believe them. And what's shocking was that William Thompson said, well, it's not accurate. It's like a chalk. Doesn't have to be. And I think that's legally incorrect because, if you're going to present something to the jury, and I understand it's only a demonstrative aid, but if you're going to present something to the jury, Lainey and I went back and forth about this because there is software now that'll let you build something that's exactly a replica. So there's really no excuse. And I think that was a legal error. I don't know if it rises to the level of reversible error, but I think that ruling was wrong.
Well, it has to be somewhat accurate. You can't have a whole different house.
Well,
you know what I mean?
There's a theory in the law, substantial similarity, and I think that's all they're going through. But it's not going to have the furniture. And did you ever have the experience of moving? And after you move all the furniture out of this place where you've been all these many months or years, the place looks totally different. So it's crazy. But anyhow, okay, let's get into the top 5 orders that have come out of the court. And this actually will shape the Kohberger trial, which is slated to start with jury selection in July and the trial in August. So the first, number 5, we're going to go backwards, kind of like the Letterman show. Use of the terms sociopath or psychopath. The defense filed a motion to exclude any reference to the terms psychopath or sociopath during trial on the basis of the characterizations are unfairly prejudicial, but also improper opinion testimony. The state agreed it had no intention to use the terms. This motion was granted. based on the lack of any evidence of an actual diagnosis of a personality disorder or similar mental illness, use of the terms would be highly prejudicial. But if the door is opened during trial, the court could reconsider outside the presence of the jury.
And I know that the prosecution has now demanded for their experts to examine Brian Kohberger. So depending on what the prosecution's mental health experts, what their findings are, I don't know what they're going to be. But if they determine that he's a sociopath or psychopath, I wonder if that's going to be allowed.
Yeah, because the way that the order was written was denied for now, or I should say granted for now, but, could be revisited, which I don't know. Does that really help determine guilt or innocence, just to use a term sociopath or psychopath? I mean, it almost absolves him, doesn't it? It says he's mentally ill and he couldn't have done it. I mean, I don't know.
Well, it doesn't prove that he entered the house and committed the crimes.
No.
I mean, they have a burglary charge, so they have to prove that he entered that house and did this. Yeah.
Okay, so number 4, inflammatory evidence. Kohberger's attorneys moved for a pre-trial order excluding evidence that was exceptionally inflammatory, arguing that such evidence is irrelevant and unfairly prejudicial. The issue here was whether the probative value of the exceptionally graphic photographs would be substantially outweighed by the danger of unfair prejudice. This was denied as premature. The court held that it will decide individual photos or evidence on a case-by-case basis, with the state required to give the defense the photos it wants to introduce in advance. Each one will be taken up outside the presence of the jury.
That seems fair.
Yeah. I don't know how else you do it. I really don't know how else you do it. I mean, obviously, from what we know, it would have been a pretty gory scene. And
that's what we thought. But there was a cleanup. One of the defense experts says there was a cleanup, but we don't know.
Yeah, no. So no, it seems fairly standard. There was a Massachusetts case that is one of the leading cases on this subject. It's Commonwealth versus Nadworny, and the allegation was M, and they wanted to show photographs of a woman's body in the trunk of a car, and so that case kind of specified how and when something is inflammatory to the point where it might so enrage the passions of the jury that they just can't see straight, and they want to convict the person that's sitting in that chair over there. So it's pretty much the same issue. I think the judge was right on this one in that, how can you make a blanket ruling without seeing the photographs? Number 3, character evidence, other crimes, wrongs, or acts. Kohberger motioned to exclude evidence of a prior traffic stop and the graduate paper on how to conduct a crime scene investigation. The motion was based on the evidentiary rule 404B, which provides that evidence of a crime, wrong, or other act is not permissible to prove a person's character in order to show that on a particular occasion the person acted in accordance therewith. But the court found such evidence, including Amazon.com purchases, do not, standing alone, bear on the defendant's character or suggest he has a propensity to commit the crime. Motion denied, but again, the state must still properly give notice under the rules for use of that evidence.
Yeah, and didn't he also rule that with regard to the traffic stops, certain things had to be edited because by Kohberger asking by the officer asking Kohberger for his phone number and Kohberger saying, why do you need that? That it could be seen as prejudicial that he's hiding something. But I would ask that as well, but I don't know. So he ordered that it be that certain parts be redacted.
Right. That's a good catch. That didn't fit on our little flashcards here that we use. But so thank you for that. Yeah, so I mean, the evidence of that stop apparently, I mean, it would be crazy. And I forget which attorney said in court, I think it was Thompson, said that, of course, they're not alleging that just because he gets stopped for speeding or not using his seatbelt or whatever it was. Of course, you can't allege that he'd do an M, because haven't we all done some bad
Yeah.
thing in a car? I
Yeah.
mean, the ink was hardly dry on my driver's license, although those many years ago when the Pennsylvania State Police stopped me for doing an LA roll through a stop sign. Oh, was that offensive to you for me to call it an LA roll?
Well, I'm a little bit outside of LA, so.
I know, but that's what we call it. Do they call it that out there, an LA roll, when you
Yeah.
slow down, you don't see any cars? So I learned at a very early age. But no, a good point. I mean, you don't jump to the conclusion that because somebody has a minor traffic violation that they, are going to commit a crime like that.
They're using it for identity and the ownership of the car.
Exactly. Yeah. Identification. Okay. The bushy eyebrows. Here we go. Bushy eyebrows. When we first started doing these series, I had an old college friend of mine help me. Unfortunately, he's passed away. But he said, Andrew, I think you have bushy eyebrows.
Well, I mean, I started noticing everybody's eyebrows after this case. Bushy eyebrows. Yeah.
So Kohberger's attorneys filed a motion to exclude any reference at trial to Dylan Mortensen's description of bushy eyebrows on the person she says she saw. Defendant claimed the description was unreliable, irrelevant, and therefore barred by the rules of evidence, all based on Dylan Mortensen's admitted drinking, uncertainty whether it was a dream or real. Motion was denied, the court finding that there is a big difference between finding a witness not competent to testify and simply allowing impeachment by vigorous cross-examination.
Right. So I didn't know how the court would rule on this, but I don't think that I would have brought a motion in limine on this. Well, maybe I would have, but she was admittedly inebriated, and it was a crazy situation, and that just makes a better witness to cross-examine.
I don't know if I'd have brought this motion either, but we both have to remember that when you are acting as a defense attorney, it can be viewed as professional malpractice to not bring certain motions to in limine, motions to suppress. And not only malpractice, but also the basis for a later charge for ineffective assistance of counsel. So,
yeah,
a lot of people are really critical of Ann Taylor. I hesitate to be too critical of her because you know what? I mean, they do want to put him in front of the firing squad as much as Bill Thompson, complains, oh, I don't want you to say that we're trying to kill the guy. Well, you are. And I mean, you've got to pull out all the stops in a case like this. You've got to do everything you can possibly do, short of counting paper clips on the defense table. But
yeah, it's somebody's life. It's not like you can strategize on somebody's case when they're facing the death penalty and decide. I mean, you got to do everything,
pedal to the metal, really.
Yeah, everything.
And the number one order from the court, DNA terms. I found this one interesting. Maybe you can help me figure this one out. Kohberger's attorneys had moved to exclude the testimony of Riley Nolan, the lab manager for the Idaho State Police Forensic Services Laboratory. Nolan was expected to testify that the DNA found on the knife sheath was more likely the result of direct transfer. Kohberger's attorneys argued that Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA and or claiming to be an opinion about the means or mechanism how the DNA ended up on the knife sheath, is irrelevant or impermissible under the rules of evidence. The order was granted in part and denied in part. Nolan's rebuttal is proper. She will discuss primary and secondary transfer, the variables affecting transfer, and why she believes the DNA on the knife sheath was more likely the result of the direct transfer. Nolan's testimony is allowed, but the court requests that the terms touch DNA, contact DNA, and trace DNA be avoided. That confuses me.
It does. because the jury is only going to hear DNA. And that's a powerful, it doesn't give the correct type of DNA, the specific type of DNA that was found on the button snap of the knife sheath. What was found were skin cells, is from what I understand, that was on the button snap of the knife sheath. So it wasn't blood. It wasn't, bodily fluids. So I would probably say skin cells that were found on the knife sheath instead of saying DNA.
Well, it confuses me for two reasons. One is that, as you pointed out, it was just a small amount of skin cells, so many that the first lab came back negative. They couldn't do anything with it and had to be sent to the FBI, and they did whatever they did. So that's the first thing that I'm bothered by. I should say three things. The third thing is, shouldn't the court either give you an order or not give you an order? How can the court request that these terms be avoided? Does that mean you have to avoid them, or the court will give you a no? Does it mean you can use them if you use the right context? It's just a little bit murky in my mind. And the third thing that comes to my mind is that I had done an episode a long time ago about touch DNA, and I had cited a couple of court cases out of Connecticut, which I know are not, they're not precedent in Idaho, but they're leading edge cases everywhere because they went into a lot of the expert material that's out there, some publications that are out there that go deep into what is touch DNA, what is trace DNA. And the Connecticut court actually threw out 2 convictions based in part on touch DNA. So if 2 convictions, and that's only one jurisdiction, this has happened in a number of jurisdictions. So if courts are not allowing touch DNA and trace DNA, it seems to me that's an important issue. And it seems to me that A, the order is wishy-washy, but B, it could be reversible error. That's only my opinion, folks, but I do think that it is grounds for possible appeal. I'm sorry.
Yeah. And I think that the court's request that those terms be avoided is in big part because he doesn't know the science. So he doesn't want to necessarily limit the experts from using those terms if they pop up, because those are the terms they use. But at the same time, they should try not to use those terms. But it is a wishy-washy order. It's not clear. He should have just said, we'll just take it up as it comes, but to telling an expert to avoid the terms that they use when testifying is kind of like he didn't want to say you can't use those terms even though you use them in your profession, but at the same time, please try avoiding using them, which is not really, it's wishy-washy.
So does that mean that if the attorneys see the expert coming into a place in testimony where they do want to get into it, and I think it's a major issue. I think it's a huge issue that there would have to be a sidebar or a sidebar, as we say here in New England, a sidebar. Would there have to be a sidebar to go over and say, Judge, here's the context. We're going to use this term. The expert is going to explain why it's important, and then he's going to explain what it was, because that's a huge issue. There's so many people out there, especially in our comments section. I can't tell you how many times I've had commenters say, his DNA was on the scene, case closed. Well, no, the case isn't closed. Or his DNA was in that house, end of story. No, it's never. We attorneys know there's never an end to the story. There's always more.
It's a movable object, and it was located in one specific button snap. And if you think that Brian Kohberger or whoever committed this crime was going to go in there and not have gloves on and open the button snap so that his DNA could get in there, then it would have gotten, and it would have been in other places. You know what I mean? It's not just the button snap. I mean, so the person who went in there was obviously wearing gloves. I assume, I don't even know, but I assume
agree.
they would be
They would have
wearing
had
it.
to have. Yeah, go ahead. I'm
Okay,
sorry.
so, and the knife sheath is a movable object. I mean, what if the connection to the knife to Maddie or Kaylee is the knife sheath, and Brian Kohberger gave it to them or put it up on eBay or something, and one of the girls bought it? I mean, we don't know.
No. There was a knife show in that area at some point before November 13th of 2022. And all you got to do is pick it up and not buy it, put it down. Now your DNA's on there. So we don't
But,
know.
we do have, what if it's true, we do have some information that he or his family account ordered a knife sheath and a knife, K-bar knife, and a sharpener. And that, I mean, we have some information, but I don't know. I don't know, I would have to see the foundation for that, just like we were talking about the Karen Reed, about you have to know where that information came from and who gave, who downloaded it and who.
How ridiculous am I being if I say, I grew up in Pennsylvania. Hunting is big. Even when I was a little kid in Boy Scouts, we learned how to handle a knife. I mean, how ridiculous am I to say it's nothing? It's reasonable doubt. I don't know. I honestly don't know. I know that there are two schools of thought that really divide our audience here. And one school says, he bought the knife. He bought the balaclava mask and his DNA is there. Guilty. Next case. And there's other people that say it's all a coincidence. People in Pennsylvania are hunters and they buy knives. People that run like he was a runner, buy these masks because it's cold in the Pocono Mountains of Pennsylvania. And, we just talked about the discrepancy about maybe it was or wasn't his DNA on the knife, or maybe he didn't leave it there. So I don't know. How crazy would people be that say, oh, those are all coincidences?
Well, they have to connect the knife that he bought on Amazon or allegedly bought on Amazon to the knife that unalived the 4 students. But right now, we don't have that knife. So then there's the sheath. Is the sheath the one that was bought from Amazon? Because just because he bought it doesn't make it that he was in the house. I mean, there's missing pieces there. While I'll agree that that's some evidence that he might have done the crime, but it by no means meets reasonable doubt.
Yeah, I guess not.
Beyond a reasonable doubt.
No, so there's a line between reasonable doubt and speculation. There really is. So I also tend to think there's a lot more. I mean, until this case went down to Boise, and until really the beginning of 2025, there was nothing. The non-dissemination order was so locked tight that there was very little. Now these little dribs and drabs are coming out. The balaclava, I know I don't say it right, so comment below about how Attorney Myers doesn't know how to say it. The knife sheath. A lot of other things are coming out, like the text messages, the 911 call. So I am holding out. I think like yourself. I'm not going to speak for you, but I think like yourself. My mind is open. I respect the constitutionally required, presumption of innocence until found otherwise. And so I haven't seen enough. I know there are podcasters that say anybody that thinks he's not guilty is an idiot, and then there's people that say anybody that thinks he's guilty is an idiot. So,
and as a practical matter, we're not the ones that need to be convinced. It's the jury that needs to be convinced. What we think out here isn't going to matter in a jury. I mean, I know that when they pick jurors, they're going to pick jurors who are not familiar with YouTube, who don't watch YouTube, who are not into true crime. They're going to try their best to pick jurors who are far away from this. And whatever we think, whatever, my little channel, whatever I talk about, I don't think the jury's going to be watching me. The jury that's picked is going to be watching me or you, because they're going to want to avoid that. So, I sometimes think it's going to be a lot of elderly people, because those are the ones that are available to serve for that long a time. And they don't work. And I don't know, but elderly people or older generations, I mean, they just want concrete things like a license plate, a video show. I mean, I can't see. When I'm looking at those cars on the grainy video, I'm
Yeah,
which brings me,
I've called it Fuzzy Wuzzy was a car. I know exactly the videos you're talking about.
yeah.
Remember when I said that there have been a lot of little surprises that have come out in dribs and drabs? Well, here's one of them. Here's one of the things that's come out in dribs and drabs. And remember in the beginning, I said there would be a bonus order. Well, here's the state's order on state's motion in limine regarding text messages and 911 call. And correct me if I'm wrong, but there were a couple of new little facts in here that took me aback. A lot of these facts are cut and pasted out of the probable cause affidavit.
And some of them are from the grand jury testimony.
Yeah.
Yeah. See,
Here we go. Here we go. So after the text, during the foregoing exchange, and we're talking about the texts that have come out, Dylan Mortensen also attempted contacting Ethan Chapin through Snapchat. There's the grand jury transcript, as you just mentioned. She again tried calling Kaylee and Xana, but neither responded. Again, grand jury testimony. Dylan Mortensen then exited her room and began running towards Bethany Funk's bedroom. On her way, and this is the part I think is new, correct me if I'm wrong, she noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. Dylan Mortensen thought Xana was drunk. So I'm thinking to myself, I don't remember hearing about this before, but on her way, Dylan Mortensen noticed Xana lying on the floor of her bedroom with her head towards the wall and her feet towards the door. Dylan Mortensen thought Xana was drunk. Well, okay, but I mean, wouldn't you notice a whole lot more if what we've heard about this incident is true? It was an extremely gory scene, a bloody scene. A knife was used. A knife was used not just to cut, but to slice. I mean, these are all terms that might get us demonetized by YouTube, but it was a gory scene. Wouldn't Dylan have seen something outrageously just awful?
I would think so. I mean, this is news to me, so I don't know. Either she was scared, or I have no idea how. But is that something common that these people get drunk and lie around on the floor? I mean, is that what happens?
Well, it's a party house. I don't know. I wasn't that wild as a lot of people in college when I was in college. It wasn't that wild, but this was a party house. We know. We've seen the video of the police going to that house 3 times in the couple of months leading up to November 13th of 2022. And sure, college kids can pass out and lie on the floor, and that's one thing. But to have undergone what we are told happened in that house, that's a whole different thing. And it would have been extremely shocking to see your roommate and your friend in that state. And it would have been obvious that something horrible, horrific, whatever word you want to use, has just happened. And if you're in a frozen shock phase, wouldn't that snap you out of it? And wouldn't any normal, reasonable person call 911 immediately? Hey, there's, she should have called 911, and I guess she was drunk herself. I don't know, or I have no idea. It's just very sad. It's very sad, but it's just this confirms my point that I made before, that it's hard to jump to a conclusion in this case because so much was unknown until the Boise court entered the scene and until pretty much 2025 when all of this started coming out in dribs and drabs and pieces. And I likened it before to a puzzle, and maybe it's 1,000-piece puzzle. And at this point we have 50 pieces. So there's an awful lot more to come, people. So I refuse to jump to a conclusion about this case. It doesn't look good for Mr. Kohberger, but it doesn't look awful. I mean, do I still see some reasonable doubt? Yes. Comment down below and tell me what an idiot I am, because people are, case closed. There's DNA on the underneath Maddie. Case closed. closed. No case is ever closed. I'm sorry. Until the jury comes back, renders a verdict in open court, and that verdict is recorded in the record of the court. It's not over until that moment. Now, if he's found guilty, he's found guilty. I have nothing to apologize for.
Yeah.
If he's found not guilty, I have nothing to apologize for. So I don't know. I just found this.
There was also something else in this that I recall that H.J.
Hunter
went in to check before the 911 call was called, and he grabbed a knife. At approximately 11:50 a.m., DM called her friend EA and asked her to come over and check the house because she was scared. Okay. EA and her boyfriend HJ came over, and this is from the grand jury testimony. They met DM and BF at the bottom floor of the house, grand jury testimony. Together, DM, BF, and HJ started to walk up the stairs to the second floor. When they reached the second floor, HJ went to the kitchen to grab a kitchen knife. When he came back out, DM saw Xana again for a split second, and I just started bawling because I thought she had just I don't even know. I thought maybe she was still just drunk and all asleep on the floor. And then it says, BF also saw Xana lying on the floor. So
HJ then told DM and BF to get out. EA, who had started up the stairs, also turned around after HJ instructed her not to come any further. They both went outside. Shortly afterwards, HJ exited the house and told them to call 911. He was pale white and mentioned something about someone being unconscious. At 11:56 a.m., Bethany called 911 from her cell phone and spoke to Carolina Calvin, the 911 dispatcher. So why would you be grabbing a knife unless you were in fear? I mean, they weren't making a deli sandwich.
No, and so he grabbed the knife. So what, did he come back out with the knife? I mean,
it says he came back out, but Dylan saw Xana again for a split second, and I just started bawling because I thought she had just I don't even know. I thought maybe she was still just drunk. Well, why would you start bawling? Why would people be grabbing knives unless you knew just exactly some kind of horrible, end had come to these people? It's more and more baffling.
Yeah, it's baffling. And the whole thing about him getting a knife, obviously, why? Because was somebody, I don't.
Well, did he think that obviously some horrible thing had happened to at least Xana and maybe more, and he needed to defend himself? I mean, I don't know. Is that what he was thinking?
Possibly.
Why don't we go to our viewers and see what they have to say? Number 5 is Colin 401. There are things you can take that allow you to stay awake and drink like a fish all. Did you know that? I didn't. There are things you can take that allow you to stay awake and drink like a fish all night and into the morning. It was a party house like a lot of other off-campus houses. The thing that gets me about this case is all the other DNA. It seems like they tested it against Brian's DNA, and since it didn't match, they stopped investigating. Did you know that there are things you can take that allow you to stay awake and drink like a fish?
No, but I'd like to know what they are.
Yeah, Colin, write in and elucidate.
Yeah. Okay. This is from Vanessa Bliss 4603. I'm surprised you get so many comments calling your channel biased. I think you do an excellent job presenting and explaining the evidence in court proceedings.
Well, okay.
They call your channel biased?
Oh, all the time. But both sides. We've been called pro-burgers and we've been called guilters at the same time. People get so deeply entrenched in their way of thinking that unless you toe the line all the way and drink the Kool-Aid, You're on the other, and this is endemic. I don't want to get into politics because I hate politics, and I hate politicians even more. And I think this is what's wrong with our country, that the lefties are so far over to the left, and the righties are so far over to the right that people have forgotten, hey, the good of the country. Let's balance the budget. Let's stop let's manage the country like an intelligent administrator, and do what we need to. And that is true here. There's the people that say he's guilty. We've known him from day one. There's that piece of DNA. He's guilty. Case closed. And there's other people that say, oh, the cops are all lying. They a bunch of local yokels over in Moscow, Idaho. They didn't know what they were doing, and they were all conspiring. And Brett Payne and what's the other guy? They made it all up.
But what I don't understand is why people feel they need to convince people of his guilt or convince people of his innocence. Because at the end of the day, we are not the people that need to be convinced. We're irrelevant.
Well, no, you're right. You're making a logical point, but people just feel the need. People just get so emotionally invested in these cases that they develop this deeply ingrained bias one way or the other. And if you follow mainstream media, and I hate that term because I did work in the media for a while, for 10 years before I went to law school. I hate to paint with a broad brush, but if you watch the big channels and the big YouTube channels, and you know who I mean, from day one, he did it. Court TV ran, what was the title of the special that they ran? He's guilty. I forget the title of it, but it just implied he's guilty, and here's how, and here's why. And it's like, you're right. It's like, it's not up to us. And the media needs the media needs a hook. And so he's guilty is the hook. And B, the media wants to get in good with law enforcement so that they'll get the call, they'll get the tip, they'll get the next call. So if you, I hate to use it.
Yeah, it doesn't, I mean, the media, mainstream media act as they assume he did it. It's like they talk about it as if he did it. So he must have thought this through. And these people that try to get into the mind of the driver of the white Elantra that was circling around, that he was casing the place, that
Yeah. So, so we've been, I think we beat this one to death. So there she is. Dylan Angel Bonds says, your frozen shock phase for sure ends when you start using the phone. Yeah. And also when you see crazy things, and go down to Bethany's room and
Devo Bronk. It says, you two are hilarious. Go ahead and stump harder in favor of the defense in the Kohberger case. But it doesn't matter a bit. Kohberger is cooked. They have his DNA on the knife sheath at the scene. They have him putting a K-bar into his Amazon shopping cart weeks prior to the murders. It's not weeks.
It was months.
And they have witnesses who saw him get rejected at a bar by at least one of the girls in the house. I don't know if that's true.
I don't know if that's true either. Earlier on, there was that whole thing about that, and then that was disproven. So, who knows what evidence they do have? These little things have been dribs and drabs, and now Dylan saw Xana lying on the floors, and Brian bought a balaclava. This stuff is coming out in dribs and drabs, and I will not be in the position of somebody telling me, "See, we were right and you were wrong," because I kept an open mind all along.
It's not about being right or wrong. It's just, I mean, if you're interested in true crime, you want to talk about it, but it's not like it isn't. Like I say, we're not the ones that need to be convinced he's guilty or not.
And I'm not. And the purpose of this podcast, unlike some others, I'm right. Look at that fuzzy wuzzy car. That's him. And if you don't agree with me, I think it's funny to watch these people. And then there's people on the other side that say, oh, you don't know what you're talking about. So that is not our purpose here, is to convince anybody of anything. I try to be a little bit above the tunnels and do some legal analysis. And I'm happy to have you here because you help with that. And our final today, Darla Boo. Hey, Darla Boo. I'm not a pro-guilter or a pro-burger, but pro-justice for these 4 victims. You are doing a great job in discussions of evidence there, see?
Yeah.
So it's all in the eye of the beholder. It's just all in the eye of the beholder. Anyhow, so we always mention on these episodes and ask people to remember that the case is about the 4 victims, and we hope people will remember Madison, Kaylee, Xana, and Ethan. In whatever it means, we hope for justice for their families, their friends, and the other people in their lives, and also for Idaho. Because what a horrible thing! I can't imagine. I live in a relatively small town, and I can't imagine, what the town. It's not a campus town that I live in, but I have lived in a campus town in the past, and it's just, you can't really imagine what people are going through. So, that's it. Yeah. So I guess my closing thought is, we just saw 5 court orders and a bonus and a couple of new facts trickling out. And, like we just said, my mind is open. Gosh knows what we will learn in the weeks and months ahead. We have to read these documents. These documents came out a couple of weeks ago, and I was busy with the Reed trial starting up, and I was busy, watching it all and, getting back up to speed on it and, just kind of shaking my head at the Reed case. And so for me, anyhow, those kind of went by really quickly. And so I go back and read them, and I'm like, how did I miss that? How did I miss that little detail?
I know. Yeah, same here. It's the day job.
Yeah. Have you been busy in your day job also?
Yeah, I get busy and then I'm not, but lately I've been busy. It just goes up and down, when deadlines come, So I was busy, and plus I got a new computer, but I still haven't been able to use it. So because of the transferring of it's a mess. But
it's a mess. Yeah, I got a new laptop because my old laptop had been giving me trouble from the day I bought it, and so I got another new. It's a gaming computer, so it's fast. I'm not a gamer. I'm just not a gamer, but it's fast. It's really, it has a lot of memory, and so it's really it's a pretty cool thing to have, actually.
Yeah. I guess that's how my new computer is going to be, but I'm afraid I'm going to touch a button and it's just going to go fast to something else.
Yeah, it's, in the old days, there were people that you could call on to help you. And I had a great computer guy, but unfortunately he retired. So, I'm in the same boat as you. I do have Lainey, that she is able to talk me through some stuff. She's a good techie that's able to talk me through some stuff. So, call her. She's on vacation, but she'll be back.
All right.
So we should keep in better touch in the future. Do you have any closing thoughts?
Oh, no, just waiting to see what's to come. I mean, there's the pre-trial conference. We'll see what happens there.
That's right. We didn't mention that, but maybe in our next episode, we will take a look at the pre-trial conference. Yolie, good to see you. Take care. Be well out there in California.
Thanks.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.